fact finding. On the asking the court to, after filing objection to the special master's report, the trial court just basically affirmed the special master's report, except for a debt that Ms. Christinas and I had agreed the husband would take. She had divided that, and so that was the only alteration in Judge Wallace's order. There are only two real issues on appeal in this case. The first is that the trial court's division of the proceeds from the sale of the marital residence, not how it divided the marital property, but only the proceeds from the sale of the house are at issue. And there are three theories as to why we think the special master got that wrong. And the second is the trial court's failure to award attorney's fees to the wife. As to the division of the proceeds from the sale of the marital residence, the facts are not really in dispute in this case. I'll talk about it a little bit later, but the wife had a learning disability. And it's talked to about, the husband admits it, and he tells everybody about how it affected her abilities. Knowing that, when we took his deposition, because the wife did not make a really good witness, we took his deposition looking for proof at trial. And so almost every fact that the plaintiff needs to prevail in this matter comes from the husband. This is not a he said, she said that we're here on. Almost every fact comes from the husband. So, just real quickly on some of the facts, the parties dated for about 2 years before they got married. The wife worked at Kroger. From the time they started dating until about 2017, she made $11.25 an hour. Everybody would go to work. She'd come home, she'd cook and clean, and that's how they progressed throughout the marriage. The wife left Kroger in about 2017 when she went to work for daycares, and she stayed working for the daycares until the parties separated in 2019. The husband worked for pest control companies his entire working life, apparently. He worked there while they were dating and all the way through the marriage. The husband made anywhere between $45,000 and $60,000 per year. He typically worked, according to his testimony, 60 to 80 hours per week. He worked basically Monday through Saturday. The husband purchased the marital home in 2005 for $115,000. The parties married in 2009. The husband quitclaimed the deed to him and his wife as tenants by the entireties in 2015. When the wife worked at the daycares, she was constantly sick. This is the proof from husband, wife, and the wife's mother. She was sick all the time because of keeping the kids at the daycare. So, and this is what we term in the brief the agreement between husband and the wife's parents. In August of 2018, the wife's parents had everybody up for dinner at their house. The purpose of the dinner was to talk about an agreement. And that agreement basically was the wife's parents would pay off the mortgage on the marital residence in return for the husband allowing the wife to quit work full-time and go back to school. The purpose of the school was hopefully to acquire a better education, to get a better job, to get away from the daycare business. Paying off the mortgage, this is all according to the husband, saved the parties about $800 a month. The wife was not bringing home $800 a month. And the husband testified that he told the wife and her parents during the meeting, quitting work and going to school was acceptable, and they were going to pay off the mortgage on the house. At the time of the agreement, which is important to the husband in this case, the husband had changed jobs. He had been working for a pest control company called Honor Guard. He changed to Max Pest Control. He was making about $45,000 at Honor Guard. Max Pest Control told him he would make anywhere between $50,000 and $60,000. This is all from the husband's testimony. But when the husband started working at Max, they only paid him $35,000. So he wasn't getting the money he was supposed to get, and he'd taken this huge decrease, and so paying off the mortgage was important to him, and that's part of the reason he agreed. Wife's parents fulfilled their part of the bargain. They paid off the mortgage in the amount of $99,130.42. There's some credibility issues with the husband, in my opinion. The trial court made no findings one way or the other on credibility. But when he was asked questions by his attorney on cross-examination, he tried to backtrack about the deal. But when he came back around on redirect examination, the husband again admitted that at the time of the deal with the wife's parents, he was in agreement that they'd pay off the house and the wife could quit work so she could go to school. The problem with the whole deal is that basically husband was an alcoholic at the time and nobody knew it. The wife didn't know it, that's her testimony. Her wife's mother didn't know it, but the husband tells everybody he concealed it. Nobody knew because he was good at concealing the problem. And there's a long list of his alcohol abuse in the brief, but basically starting in December of 2018, 3 months after the agreement was made, husband checks himself into Cumberland Heights. There's a period of time where he stayed there, I think 14 days. It was cost him $800 a day. There was a $5,000 deductible. He didn't have the money for that. Wife's parents paid half of it, $2,500. His parents paid $2,500 of it. Husband didn't get paid during those 14 days. Then he's admitted to St. Thomas West on March 12, 2019, another rehab facility on March 31, 2019, and then finally the straw that broke the camel's back is on Memorial Day of 2019, after all the liquor's out of the house and everybody's trying to straighten up the alcohol problem. He finds mouthwash and consumed enough mouthwash where he testifies he doesn't remember any of the events of that day. That's the date of separation, May 27, 2019. There's one more that we know about, rehab incident in August of 2020. Husband testified that he was in rehab for 21 days and outpatient for 30 more. Wife went to school. She finished one semester at Nashville Tech, or what I've referred to as Nashville Tech. She started the second semester but didn't complete because that fell within the time when she needed to quit school, go home, take care of husband, and just be a wife, not be off at school all the time, but kind of manage him and make sure that he wasn't drinking. So the argument on this is that it's basically threefold. One, the parties had an agreement. Husband, wife, and wife's parents had an agreement. Quit work, go to school, get a better job, we'll pay off the mortgage. And we think he breached the contract by knowingly concealing that he was an alcoholic. And when it hit and it became obvious and it affected him in his job and just living at home, that constitutes the breach of the contract. I've cited cases in the brief that says that even a partial failure of consideration can serve as a ground if it's such as to affect the whole contract. Also, the failure is a material breach if the subject matter that's breached is of such prime importance that the contract would not have been made. The only testimony in this record is whether or not the parents would have made this loan comes from wife's mother, and she said she wouldn't have made this loan, or she wouldn't have paid off the debt, sorry, if she had known that he was an alcoholic. So that's the contract breach part. Also, under the statute, as the court well knows, the division of marital property should be equitable. Doesn't have to be equal, needs to be equitable. And so here, you've got a windfall coming to the husband if this court doesn't fix the trial court's judgment, because he's going to get half of $99,000. He's going to get $49,565.21 that would not have been there. The net proceeds from the sale of this house was $205,000. So basically $100,000 of the net proceeds come from the wife's parents. And in 3 months from letting her quit work, he's destroyed her her being able to go to school, but also he's destroyed the marriage because there's a long period of time where he just got worse and worse. This court's very familiar with 36-4, 121C, which are the factors. This is a 10-year marriage at the time of separation. Because of COVID and everything, it's 13 years before they get divorced. Wife's age and everything plays into this, mostly the learning disability part. The husband admits, and I'm going to run out of time, but he admits in there in a long series that I've set out in the brief, and especially the reply brief, that he knew she had a learning disability when they got married. He describes how it affects her. She just has a hard time talking with people and grasping common concepts. Sometimes when people talked about her, she thought they were making fun of her, and that made her angry instead of it just being a joke. So it affected her at work at Kroger's. He tells us all about that. income potential. Wife made $11.25 at Kroger. At the time of the trial, she was working at the Lodge Assisted Living. She was making $12.25 an hour, working 40 hours a week. If you do the math, husband's making $45,000 a year at the time of trial. Wife's making $26,000. And he's had a long experience with the pest control industry. He'll probably do that the rest of his life. One of the other factors is dissipation of assets, and when the court makes an equitable division. In this case, the husband admitted that he had over $27,000 in medical expenses because of his drinking. That's the rehabs that he paid for, or somebody paid for, that he still owed. And so that, we say, is a dissipation of assets. This one, it's in the brief, and I'm going to run out of time, but husband lived with his parents from separation through the trial of the divorce. Just before the trial of the matter, husband decided to start paying his parents $500 a month in rent. I think the brief says he lived there for 31 months not paying any rent, and 2 months before trial, he starts paying, well, before his deposition, I'm sorry, he started paying $500 a month in rent to his parents, all cash. Then when we get to trial, 2 months before trial, he started paying his parents $1,000 a month in rent, all cash. So it was just hide the money from everybody. And on attorney's fees, which I'm going to run out of, the other part is that wife's parents made a gift of paying off the mortgage to
each of the three theories, alternative theories you're offering here, basically rely on factual determinations that a special master has made.
Yes, sir.
And the court has now approved. So, we're pretty much stuck with all those factual findings, are we not?
I think that the standard review is back-to-back findings by the special master in the court are binding on this court. There are not findings of fact, though. Okay, there are not any findings of fact on any of this. The special master runs through, this is what they've got, and she cuts it up basically in half and says, there you are. So there aren't any findings of fact as to whether or not he had an alcohol problem or not, which is denied by them, whether or not there was an agreement at all. None of that's there. And I guess it's red, but I got 50 seconds. I don't know what that means.
I think it's counting up now.
Oh, okay, I'll sit down.
Your point is the master did not make findings of fact. The master made conclusions of law.
Yes, sir. That is basically it. Yes, sir.
Thank you. Thank you, Mr. Dance. Good afternoon.
Good afternoon, Your Honors. Cherry Cash with the Rutherford Cannon County Bar Association on behalf of the Appellee, Mr. Erik Jakobik. I want to address, first of all, that last question that the court asked regarding the findings of facts. That's not been alleged as a ground for the appeal in this matter. It's not cited in the brief anywhere filed on behalf of the appellant that the special master nor the trial court issued any sort of specific findings of facts in any orders that have been generated to bring this matter to conclusion at the trial court level. So I would submit that if he is making that argument before the court today, that he should not be permitted to do so because it's not been alleged in his brief. And it's not been brought before the court as one of the issues.
I still want to, it seems to me that those arguments are wrapped up in the facts here. And so the special master did say, both parties testified that they believe the money given to them by the Littletons for the new oven, the remodel, the new driveway, and the payoff of the mortgage for the home located at their home address was a gift to both parties.
She did.
Yeah, so,
She further found that there was no evidence presented to support the allegations that husband dissipated any marital funds. She further found that there was no proof that he was abusive to wife. And, Your Honor, she further found that wife was not required to drop out of school as a result of husband's addictions. So there were findings of facts included in her final order. So let me address the issues that Mr. Dance has brought on behalf of Ms. Jakobik, Littleton in this matter that are before the court today. The two issues he's brought before the court are the division of the proceeds, the $205,238.27 that remain in escrow as a result of the sale of the real property that the parties owned. My client owned this property, and he bought this property on his own in 2005, so he owned this property prior to the marriage. He did they refinanced it at some point in time during the marriage, and he did quit claimant to her as a result of that refinance. He never disputed during the marriage that that property was in fact that it was marital property and subject to being equitable division by the trial court. What happened was, what was glaring to me in the brief filed by Mr. Dance and the wife in this matter was that they keep calling this a deal. They keep calling this an agreement. They didn't call it a contract. There's no legal term that I know of, and I could be wrong, but I don't think I am. There's no legal term called a deal. There's no legal term called an agreement. We call it a contract. And we call it that, and it's defined as that because as lawyers, as courts, there's specific elements that are required to form a contract. And they never referred to it as a binding contract because it wasn't one. There wasn't one made. And when Mr. Jakobik went to his in-laws' house in 2018, he didn't know why he was going there. Mr. Dance stated that he was going there with the understanding that they were going to make a deal. He was invited to dinner. And at that dinner, they proposed to him that, and said to him that they were concerned that their daughter was getting sick working at the daycare. At that point in time, there was no proof presented to the trial court that with the income that Mr. Jakobik was earning at that time and that Ms. Jakobik was providing as a result of her job through the daycare, there was no evidence presented at the trial that they were struggling, that the mortgage was behind, that he wasn't able to pay the bills. And so he had no reason to ask them to pay off the mortgage. They proposed to him that they would do this for them, and as a result of that, it would lighten the load, so to speak, so that he could not have that $800 a month mortgage payment. Of course he accepted that. He said, yeah, that'd be great. She can go back to school. I think that'd be great for her. He did not allow her to, as Mr. Danton stated, to go back to school. That wasn't his. I think they're trying to make that look like that was the consideration that he was providing to the Littletons for purposes of forming the contract. For purposes of forming this contract, Mr. Jakobik would have had to have gone in there. They would have had to have discussed and had a meeting of the minds, so to speak, to form a contract. Like, this is what's going to happen. We're paying off the mortgage. This is what you've got to do, wife. This is what you've got to do, husband, as a result, as your consideration. There has to be that acceptance. And when everybody walked out that door that night, there has to be a mutual understanding. Everybody has to know what's going on and what their responsibilities are in order to form a contract. And Mr. Dance doesn't include that word contract in his brief because there wasn't one. There was testimony presented by the husband, and it's cited in my brief, that he didn't know if she was supposed to work full-time, if she was going to just quit her job and not work at all, if she was going to go to school full-time, what that would look like. Even when Ms. Littleton testified, she testified that she thought that wife was going to work part-time and that she was going to go to school full-time. And so nobody really knew what was going to happen. They just knew the mortgage was going to be paid and that the wife was going to start school. So I would submit to your honors that there was no contract that was entered into in this matter. There was no meeting of the minds, and that the contract specifically fails for lack of consideration, as I've set forth in my brief. What was interesting to me in his brief was that he first said, hey, there's a contract, and husband has breached the contract. Then he argues that it's a gift. It can't be both. But I would submit to the court, I agree with him on that matter, that it absolutely was a gift. And all the proof that was presented at the trial in this case it supports the special master's finding and the ratification by the trial court of the special master's findings that it was a gift, and here's why. As set forth in my brief, I asked wife specific questions about her understanding of the of what took place. I asked her, you understand that you both were on the mortgage? And she said, yes. And I said, so when the mortgage was paid off, you both understand that you both benefit from it? And she said, yes. And I said, so you would agree with me that it was a gift to the both of you? And she agreed with me that it was a gift to the both of them. Then when I asked Miss Littleton, the in-law, the mother, I had her on the stand and I asked her, here's what happened when she paid off that mortgage. Shortly after they walked out of her home that evening, after having dinner, she went to Regions Bank and she obtained a cashier's check from her account, $99,000 and some change to pay off the mortgage. And when she got that cashier's check was submitted as an exhibit to our proof at the trial in the matter in her own handwriting. It was very interesting. In her own handwriting, she wrote on the check for Ann Jakobik and Erik Jakobik. And I asked her why she wrote that, and she said, because the bank told me to. And I said, you wrote that on the check because you knew it was paying off the mortgage for both of them, that they both would have benefited from it. And she admitted to me that she knew they both would have benefited from it. But what the statement she did make is she said, I would have never given him that money had I known he had an alcohol addiction at that time. She admitted on the stand that she knew it was a gift to both husband and wife. There's no way it couldn't have been, Your Honor. She knew that he was on the mortgage. She knew that he would benefit from it being paid off. It wasn't just a gift to the wife. It was a gift to the marriage. It was a gift to the parties. And they both benefited from it. Further, I asked her if she was supportive of Mr. Jakobik at that point in time, and she stated that she was, and that it was her intent to help both of them. So they can't say he breached a contract that in our opinion was never formed, or alternatively that it can't be both. It's got to be one or the other. I would submit to the court that it was a gift. As a result of, I would bring to the court's attention, as set forth in my brief, that pursuant to Higgins versus Oil, Chemical, and Atomic Workers Intern Union Local number 3-677, the Tennessee Supreme Court stated in that case, the requirements for a valid contract are well settled. While a contract may either be express or implied, written or oral, it has to have certain things. It has to be sufficiently definite to be enforced, and there has to be an absolute meeting of the minds. And I would submit to the court that that was not the case here. As it relates to the school issue, I would want to tell the court that when I asked Ms. Jakobik questions as to why she quit school, she did quit school while this divorce was being. She said the divorce became too hard on her. What was interesting, though, is when we got to the trial some 2 years later, I asked her, after the divorce was granted or after you separated from Mr. Jakobik, did you go back to school? She said, no, I wanted to do something else. She could have very easily gone back to school, and she chose not to do so. As it relates to the dissipation of assets, Your Honor, I would submit to the court that the special master found that there was no proof presented to the trial court to show any sort of dissipation on behalf of Mr. Jakobik as a result of his alcoholism or his treatment resulting from his alcoholism. There were no receipts. There were no proof of expenses. There was no showing to the trial court that Mr. Jakobik had in any way, shape, form, or fashion reduced what was in the marital pot on that day that was subject to being divided by the court. And that is what is defined as dissipation, Your Honors. As it relates to attorney's fees, the court was very clear in its ruling that what the court did is the court said, these parties are going to divide the equity in this home equally. And the court, as a result of that, said that each party therefore has the ability to pay their own attorney's fees. At the time that, it's very clear case law that attorney's fees are awarded to a prevailing party in a divorce action as alimony and solido. At the time these parties were declared divorced, Ms. Jakobik had a job. She was living in her parents' condominium, rent-free, mortgage-free, and the only thing she was paying was utilities. She had the ability at that point in time, she testified, to contribute to her 401k, and she was asked during the trial whether she had the ability to pay all of her expenses at that point in time, and she said yes, that she had no problem. She wasn't struggling paying any of her expenses. At that point in time, there was a difference. There was a discrepancy in my client's income and Ms. Jakobik's income. He was at about a $45,000 level, and she was at a $25,000 level. But my client also took the majority of the debts in the marriage. And I would submit to the court that him taking the disproportionate share of the debts was why the trial court allowed for both parties to pay their own attorney's fees. The trial court found that both parties had the ability to pay their own attorney's fees. For these reasons, we would ask that the court affirm the trial court's decision, find that it was equitable to divide the $205,000 equity as a result of the sale of the marital home, and that it was proper that the trial court found that the parties had the ability to pay their own attorney's fees. Thank you.
All right, thank you. Rebuttal.
Yes, sir. And Judge, very respectfully, I do not believe that the special master's report, that one paragraph, are findings of facts as required by the rules. What the special master says was there was no evidence presented to support the allegation that husband dissipated any marital funds. Stop right there. Like I said, almost all the proof in this case comes from the husband. The husband went through, as he testified, and told us how much he was in debt for all the rehab facilities. He went through there one by one. So the special master could have said, I heard this testimony, this is what he testified to, I don't believe it. You didn't give me receipts, I don't believe it. But she said there's no evidence presented. There was evidence presented, we just don't know which way she was thinking. I mean, she says there was no evidence presented, which is just not correct. It was presented. She could have said, I don't believe it, and move on. The same thing goes to whether—
no evidence of dissipation.
Yes, sir.
Is different from there being evidence of debt. The mere fact that there's a debt
Correct.
Doesn't mean there's dissipation.
Yes, sir. But I guess my point in the brief was, instead of spending all this $27,000+ on the family or doing whatever, he had to pay for rehab for the alcoholism as he went through. I think under the case law, that is dissipation. The special master also said there was no evidence in that same time that the wife was required to drop out of school. Again, you had the same issue. The wife testified she had to drop out of school to go home to take care of the husband and kind of monitor the alcoholism. The special master said, I don't believe it. And that had been a finding of fact, credibility. She didn't do that. She said there was nothing there. So I just don't think that rises to findings of fact as required by the rule. Ms. Cash's point on, we refer to it as a deal, that's what it is. You can have an oral contract. These people had a meeting of the minds. I don't have time to go through it, but in the brief, the husband says it twice in two different sections, one on direct and one on redirect of him. I was very happy with this deal. They were going to pay off the house. I was going to allow her to go back to school. On the part about the attorney's fees, real quickly, that I didn't get to, clearly in this case, and there's not a finding of fact, but that the husband was the cause of the breakup of the marriage. The alcoholism was there. It's not refuted that when the wife testified, this is when I left, was the mouthwash incident, which was the fourth alcoholism she showed. She said, I was done. That's the cause of the breakup. And there's a case that's cited in the brief that goes through there with a fact pattern that's similar. Anyway, the husband was an alcoholic. He's also had multiple affairs, which aren't applicable here. The wife's parents had contributed to, the wife's parents in that case, had contributed to the upkeep of the family. And the trial court in that, which is approved by the Court of Appeals, goes, all these factors ran in, and you need to award the wife the attorney's fees, mostly because of the breakup and all the financial support she received from her mother. That's it. Thank you.
All right, thank you both. We'll take your case under advisement. Thank you, Your Honor. That concludes the afternoon docket.